Hello, I'm Michael Ruger. I'm a certified divorce financial analyst and the managing partner of Greenbush Financial Group, and today we'll be talking about how alimony payments are calculated in New York. This is obviously one of the biggest topics that come up when we're dealing with clients that are about to go through the divorce process or in the divorce process, because whenever there's a difference between the income levels of one spouse versus the other, typically alimony comes into play to help support the spouse that has the lower income. So we're going to go over the typical alimony awards that we've seen working with clients, the duration of those payments, how long are they typically paid for based on the length of the marriage. We'll talk about how alimony is taxed, and also some of the events that can happen that can end the alimony abruptly after the divorce has been finalized, because we want you to be aware of those as well. So the big thing to be aware of is alimony payments. People will often ask, what is the average payment? And unfortunately, there's really not an average alimony payment out there that we can stick to, just because it really depends on what the income is between the two spouses, how long they've been married. There's also special circumstances that come into play. The more you read different alimony articles, you're going to see stuff like there's gray areas, and it varies because New York did something big back in 2015, which they finally came out with a standard calculation, which was never there before. So before 2015, all you could do was look at the facts and circumstances and possibly some previous case law and say, this is what we think the alimony should be. There was never kind of a standard formula that judges, attorneys, mediators could rely on. Well, in 2015, New York came out with some of these formulas, and it's really impacted the way alimony payments are awarded, the amounts, and the duration. And we'll kind of go through some of those calculations today so you know what they look like. Now, spousal support goes by a few different names. Some people call it alimony, some people call it maintenance. There's temporary maintenance, post-divorce maintenance, but really we're all talking about the same thing. Other than child support, these are those payments to supplement the lower income spouse. Now, there's two flavors of alimony. There's temporary maintenance, and then there's post-divorce maintenance. Now, temporary maintenance is when you're actually going through the divorce process, still married, going through the divorce process. The lower income earning spouse needs some income in order to meet their expenses while you're working towards your divorce agreement. There's that temporary maintenance calculation that comes into play. Now, the post-divorce, that's when you have your actual divorce agreement. It writes in the terms that this is how much alimony payments are going to be and the duration of the payments once a divorce is complete. Now, with temporary maintenance, they have separate formulas. So there's one formula for temporary maintenance, and then there's one formula for post-divorce that New York came out with that now attorneys and spouses can look at to see where they're going to be. Now, let's look at temporary first. So temporary has two calculations, and you run the calculations, you run them both, and then you really choose the lower of the two is kind of the one. If you're using the New York State formula, you take the lower of the two, and that's kind of the temporary maintenance amount. So let's look at the formulas. So the first calculation is you multiply the paying spouse's income by 30% and then subtract 20% of the supported spouse's income. That's calculation one. Calculation two, which is separate, you add both of the spouse's incomes together, multiply it by 40%, and then subtract the supported spouse's income from that amount. Now, I'm throwing formulas at you. We're actually going to walk through an example here so you can see how it works with numbers. So in this example, husband makes $100,000 per year and wife makes $40,000 per year. So if we run calculation one, we first take the husband's income, $100,000, times that by 30%, and then we subtract the wife's income times 20%, and that gives us a result of $22,000 per year, or roughly $1,800 per month for temporary maintenance. Now, if we run calculation two, we add both of their incomes together to get $140,000, times that by 40%, then subtract the lower income earning spouse income of $40,000, and that results in a $16,000 annual maintenance, or roughly about $1,300 per year. Since calculation two is lower at $1,300 per year, that's the one that the temporary maintenance is awarded on. Now again, these are standard calculations. Judges do not have to accept the standard calculation. Mediators, collaborative attorneys, they do not have to accept the standard calculation, but what we've seen is this is usually where the conversation starts. Now that there's a calculation that can be run, saying here's the basis amount, if we just take it for book value, this is what it comes out to be, and then the negotiations start from there, because there's definitely other factors that play in. How much was the income? I mean, if your household income was $600,000, there's probably a lower likelihood they're going to peg it to the actual calc. The calc does have an income cap for temporary maintenance, but it's over $500,000 before we hit the cap, so it's only then that income comes into play. But you could have other circumstances, like you could have a child with special needs, there could be health issues with one of the spouses. They're going to take other considerations when they award that temporary maintenance amount. Now, post-divorce, like this is when this is in your agreement, it's a separate formula that they use for post-divorce. Now, and it's also, unfortunately, a more complex formula. And the biggest piece that decides what formula you go with in the post-divorce is whether there's child support being paid or not. So instead of going through that calculation in detail, there's actually a link to the calculator that we've chosen to be the most simple, straightforward, that you can put in the spouse's income. It'll say, you know, am I going to get child support? It'll run that calculation and say, this is the, based on the New York calculation, this would be the post-divorce alimony amount. If you go to our website, which is www.divorcefinancialplanningscenter.com, and look for the alimony article, the link is right in that article that you can go right to that calculator. Now, before you do that, before you jump to the calculation, let me go through a few things that you're going to have to consider once you see the number that results in. The other thing is the duration. So you get the number, you run the calculation, you get the number, and then that's up for negotiation. But it's like, how long are those payments set to last for? Now, New York also gave some guidance on this when they came out with those regs in 2015, and it's based on certain windows of the duration of your marriage, how long you were married. So here's what they gave in the regs. So if you're married 15 years or less, between 15% and 30% of the total time you were married is the duration of the alimony payment. So if you were married 10 years, alimony payments may be between 1.5 and 3 years, for example. Now, again, up for negotiation, but a lot of times we do see it come pretty close to that range. If you were married from 15 to 20 years, it's between 30% and 40% of the total time you were married. 20 years plus, between 35% and 50% of the total time you are married. Now let's move over to how alimony is taxed. So this is something that changed very recently. So as of 1/1/2019, for any divorce agreements that were put in place after 12/31/2018, now the alimony is taxable to the person paying it and is tax-free to the person receiving it. It used to be different. Before the tax reform happened, it was tax deductible to the spouse that was paying it and taxable to the person receiving it. Now, this created an issue because it was kind of a tax, what we call a tax arbitrage, because you were taking income from the high income earning spouse, which they needed the tax deduction, and shifting it over to the lower income spouse, and they have a low tax bracket anyways. And usually in a divorce situation, you're trying to create as much assets and income to be divided as possible. But what this did is, by taxing at the higher income of the spouse, the IRS has taken a bigger piece because they're going to be taxed at a higher rate, especially after you get divorced. If you then go to the single tables from the married filing joint, then that spouse could be paying, depending on their income level, 40% plus, where the spouse that was receiving it under the old rules might only be paying 20% on that amount. So it definitely has impacted some of the wards because people just have less income to work with some of the tax changes in play. Now, one of the things that we've seen, and this has been kind of a very unique approach to try and get around some of these rules, is people have written into their agreement that they realize if we get divorced, we're going to have this tax situation, but if we get legally separated and we continue to file a joint tax return while I'm making the alimony payments or I'm receiving the alimony payments, this tax issue goes away because it's kind of a wash. We get the married filing joint rates. Now, before you just jump to that solution, you should really, the difference between legally separated and a divorce, there's other things that come into play. Like you can't separate retirement assets because you're not legally divorced yet. You have to file a joint tax return and both of you are still liable. But for couples that have financially trusted each other and said, yep, we realize this is an issue, we'll file a joint tax return while the alimony payments are being made, and then we get divorced as soon as like the alimony payments are done. So we've seen that as kind of a temporary solution to some of these new rules, and it's been written right into the agreement. I think the biggest impact of the New York regs that came out was probably the income cap that they put on the alimony calculation. So I said before there was really no guidance, and I mentioned on temporary maintenance, the income cap is over $500,000. Well, the income cap on post-divorce maintenance, as of right now, is about $184,000, which means when you run the calculation, and let's say the spouse making the higher income is making $300,000-$400,000, they're only putting $184,000 in the formula because that's where it's capped at. Now you can see where this creates an issue for the spouse that's the lower income earning spouse, because they say, listen, I'm used to living a $400,000 lifestyle and you're telling me we're only going to factor in $184,000 into that income calculation. That's going to generate a much lower benefit. And that's where the calculation has kind of created a crux. But again, standard calculation, no one's bound to it. Judges aren't bound by it. Attorneys, mediators are not bound to it. But again, it's kind of a starting point. But a lot of people kind of say, I don't want to even start at that starting point. But that's been kind of one of the hurdles we've had to get into with the new formula. Now, let's skip over to the events that can all of a sudden end alimony payments. So once you're divorced, legally separated, the alimony payments are being made. There's certain events that it can occur that can abruptly end those payments. The one is either spouse passes away. If either spouse passes away, typically the alimony payments end. If the spouse receiving the payments remarries, typically the payments end. If the spouse receiving the payments has a significant other that's living with them on a permanent basis and they're sharing expenses, that can potentially be grounds to reduce or end alimony payments. The payor spouse, if they involuntarily lose their job and become unemployed, that can cause an adjustment. Now there's two others that are we've seen less likely to influence alimony that can happen, such as if that payer spouse voluntarily leaves their job and goes to a lower paying job and then turns around and says, I can't afford the alimony payments. That really doesn't hold up as much as the involuntary termination. Or if the payer spouse decides to say, I'm declaring bankruptcy, I can't make the alimony payments, that one typically does not hold up either. It's just like it's more of a long shot. Now, these rules that New York put out in these formulas have been kind of both a blessing and a curse. It's been good that it's kind of narrowed down some of the gray area that alimony payments were in before, but at the same time it's been a curse because if you want to get outside of those standardized calculations, you really need financial proof, which is why we work with clients to create budgets, to create financial projections that you can give to mediators, to your attorneys, to a judge, or even in a court setting and say, okay, my financial planner ran these, this is my expenses, this is what I need to live off, this is why that calculation is or is not prudent for me based on what New York has set forth, and I need more than that. So the burden of proof has become more on the spouses to say, I need something outside of the rules. If you have any questions on the new alimony rules or in general, please feel free to contact us at greenbushfinancial.com. Thank you.